All right, so we're on Williams versus Ryta Food Corporation. Would you like to reserve some time for rebuttal?
2 minutes, Your Honor.
Done. Go ahead.
May it please the Court, my name is Doug Stein. I represent the appellant Rose Williams. This is an appeal of a summary judgment against Ms. Williams, who was injured when she slipped and fell in a puddle at a supermarket. The burden is on the plaintiff to show that the store had at least constructive knowledge of the condition of the floor, and Florida Statute 768-0755 provides two manners in which the plaintiff can prove that. Number one, that there is evidence that the condition existed for a sufficient amount of time so that the store would have constructive notice of it.
Why don't we talk about May Williams' testimony, her deposition and affidavit, and whether there's a sufficient contradiction there that renders the affidavit subject to be stricken, and whether the trial court considered evidence by refusing to consider the affidavit. That was a very long question, but you have the gist of my question, right?
I do. So May is Ms. Williams' sister, and she had testified at her deposition that the puddle, the water in the puddle, was clear. Later, she submitted an affidavit where she attested that the water was dirty and that there were tracks and shoe prints that went both directions through the puddle. The trial court refused to consider the deposition under the Ellison doctrine on the basis that the affidavit, I'm sorry, that the affidavit conflicted or contradicted her previous deposition testimony. Number one, it didn't. Let's talk about when she first testified that the water was clear, and then later attested that the water was dirty. The opposite of clear is not dirty. And the Florida Supreme Court and this court have both held that when we're considering whether the deposition testimony and attestations in an affidavit contradict each other, the attestations, the later attestations, have to be construed in any manner that can give a reasonable reading so there is no contradiction. Now, in my brief, I tried not to be vulgar, and I kind of said that you look at a fish aquarium and the water certainly can be clear, but no one's going to drink it because it's dirty. And we can even go to this, we can think of more vulgar examples is what I was saying there. We can go to this water. This water on the floor certainly could have been clear, but I'm sure if a little 5-year-old child had ran up to the water, put their hand in it, and they tried to lick their hand, their mother would be yelling at them, "Don't do that, that water is dirty." So this court, in cases cited in our brief, has definitely considered clear water to be dirty. So the opposite of clear is not dirty. The affidavit did not contradict the prior testimony.
Well, you know, I'm not sure I'm persuaded by that argument. But I know that in the affidavit, May said also, besides dirty, she said tracks through the water, and it was a long puddle of water.
Correct.
So even if we found that her testimony about clear and dirty was, that she changed her testimony on that point, did she change her testimony on the other 2 points?
Absolutely not, Judge, because the other 2 points were not addressed in her previous deposition. She wasn't asked those questions. She wasn't asked, were there footprints going through it? She wasn't asked whether there were tracks going through it. She wasn't asked about the size.
I think all she was asked was, quote, "Your sister described it, the puddle, as clear water. Is that your understanding as well?" I believe so.
Correct.
My understanding is that's the totality of the inquiry of May regarding what she saw the water look like.
You are correct. And so even if we were to disregard the affidavit in regard to whether it was dirty or clear, it's undisputed that it was big, that it was long, and that there were footprints and tracks going both directions.
Now, would that be enough to establish constructive notice?
There are cases that state that, yes, it is enough. There are other cases that say that maybe you need additional indicia.
Well, doesn't it at least create a genuine issue of material fact?
Well, absolutely, yes. But even if we were to...
We don't have to decide that it's sufficient constructive notice if it's just a genuine issue of material fact, right?
That's correct. This is a summary judgment. That's all that this court needs to find, and that's where the trial court went wrong.
Under Ellison, if we were to agree with the trial court that even though the opposite of clear is not dirty, that there was a repudiation of prior testimony that the water was clear, can we consider the affidavit piecemeal in the manner in which you suggested to my colleague, Judge Logue?
I don't know of any law that says that you can't. I have to be honest with you. I don't know law one way or the other, but I have to imagine if you have a 20-paragraph affidavit and making 20 different points and there's a contradiction in one, it couldn't possibly affect the other 19 where there is no contradiction.
But wouldn't the proper procedure be to strike the portions of the affidavit that are in conflict with the prior testimony and let the remainder of the affidavit stay in the record?
That would be proper. But
I mean, the trial court cannot consider and weigh evidence in the record, right?
That is
It's
correct.
got to make a decision on either striking or allowing an affidavit to remain in the record before it makes a decision as to whether or not there's a genuine issue of material fact, right?
That is correct. That's so.
But in this case, the affidavit remained in the record. No one struck it. No one asked that it be stricken, correct?
That is correct. They did ask, they did argue the Ellison argument to the judge, and the judge just, didn't consider it, or even if she did consider it, it definitely created an issue of fact in regard to whether the tracks were through it, whether there were footprints through it, and the size of the puddle, all of which are indicia of constructive notice. Even if we were to go further and see what other evidence is in the record, as Your Honor says, is that enough? And the appellee talks about the plus factor. Well, here we do have that plus factor. For instance, not only do we have the testimony of Rose herself as to the size of the puddle, where it was dripping from, dripping above, to the point that she said it was a long, big puddle. So there had to be a methodical dripping for a period of time in order to form that long, big puddle. We also have the issue of the inspection or lack thereof. Again, a lack of an inspection for a particular amount of time prior to when the fall occurred.
Does that lack of inspection argument still hold up in light of the enactment of the statute?
Yes. I'm not sure why it wouldn't. Does Your Honor have something in mind that needs to be addressed?
I thought the statute, maybe I'm wrong, I've got to go back and read it again. I thought the statute was much more demanding in terms of, or much more traditional in terms of constructive notice.
No, it just says, Your Honor, that the dangerous condition existed for such a length of time that in the exercise of ordinary care, the business establishment should have known of the condition. That's what the statute says.
And so the lack of inspection is a basis to infer that the puddle existed.
That is correct. When coupled with other evidence. And I think that a lot of the cases, link up the evidence with the evidence. And here we do have 3 or 4 different types of evidence. And here, I see my time is up. If I can just finish up with the lack of inspection argument, that there was...
You can continue as long as you want to. You're just working into your rebuttal time.
Okay, thank you, Judge. So the lack of inspection, there was no inspection. It's undisputed in this case. There was no inspection in that area of the aisle for at least 20 minutes prior to the fall. And there are a legion of cases we talk about that is an indicia of constructive notice. I'll save my last minute and a half for rebuttal.
Thank you.
Good morning, Maureen Piercy on behalf of the appellee Ryta Top Value Supermarkets.
I want to give you 11 minutes so that Mr. Stein can have his full 2.5 minutes for rebuttal.
Thank you, Your Honor. The first thing I'd like to address is the affidavit itself, since the court is clearly concerned with that. And I'd like to go back to the deposition testimony of Ms. Robinson. She stated in her deposition that she took notes. So she...
I'm sorry, say that again?
At the time when she was deposed, she said she took notes
Right.
when she was at the grocery store. So there's a couple things. First, she wasn't in the same part of the store when her sister fell. So Ms. Williams falls. She goes and finds her sister in another part of the store. They then proceed to find a manager at the front of the store. They speak with the manager. They make a report. They then go back to where the accident happened. This is when she observes where the slip and fall happened, and she sees water. She says in her deposition that it was a puddle of water. I believe she uses the word large. No description of size, so large could mean a couple inches, it could mean a couple feet.
But that wasn't explored in the deposition, correct?
Now, there was no discussion, correct, of the size of it. And in fact,
It isn't up to her to create or establish those definitions.
Correct.
It's up to the questioner to ask the right questions.
well, my point with that is, in the affidavit, she uses the word large also, so we still don't know what that means. That wasn't large.
That's not her
meant-
fault.
But the affidavit was something that they presented and just used the word large also, is my point. So we still don't know what she meant by large, okay?
You said
Wouldn't
very
that-
long,
Very
correct?
long?
Yeah.
Okay. So we have a period of time, we don't know how long it was from the fall to when she proceeded back. And she said at her deposition, she has notes, and they went through the notes, and I'd like to just go to a couple pages where she talks about the fact that she got notes, she got named, I saw a puddle of water on the floor, she believed it was clear. Her sister Pat Allen took photographs, and all three sisters were deposed. All three said Pat Allen took photographs. Those photographs aren't in the record, which is a little curious if they show this, dirty puddle with track marks through it. It's a little interesting that that was never provided. So she says she took notes, she got names of people and everything else.
She didn't actually say she took notes regarding the condition of the puddle, though, correct? She said she took notes regarding
The accident.
the individual she interacted with.
So
Same day, later the same day.
it sounded like it was later that same day.
She said later the same day, the very same day. Yeah, okay.
So she didn't have a pad and paper with her.
Okay, but
at
let
the
me ask you
store.
this. Let's just assume the hypothetical. This panel finds that in the record, in the summary judgment record, there's evidence that water was dripping down from a beverage cooler. The source of the puddle was water dripping down from a beverage cooler. There were tracks in the water, and it was a long puddle. Would that establish an issue of fact regarding constructive notice?
If we had, if the first part of that you're saying is we have evidence of water dripping from the cooler, slow drip to the floor,
Yes.
plus a puddle with tracks and
Yes.
dirt, I believe at that point you do have an issue of fact. The difference, what we have here is, the only testimony we have about anything coming from that cooler is Ms. Williams, and what she said was, I saw some water. These are coolers, we've all seen them in the grocery stores where it's an open cooler, and sometimes they sweat a little bit, and we've seen that. That doesn't mean it's dripping on the floor, and it doesn't mean it's
Didn't she
creating a puddle.
testify, I saw water dripping into the
Down.
puddle?
She didn't say into the puddle. She said she saw, after she fell, she saw water dripping down from up top. She thought it was coming from the cooler area, but when she was asked further about that, she said she wasn't really sure. It could have been coming from the ceiling. She didn't know. Another interesting thing is you had a discussion regarding this witness to the accident who apparently was trying to speak to Ms. Williams, but there was a language barrier.
But, in this
He was also
posture,
pointing to the ceiling.
the non-movement and summary judgment, she gets all of the good facts.
She gets
right?
the good facts.
And all the,
Correct.
logical, reasonable inferences from those facts. In other words, so, it
don't
doesn't
disagree
matter
with
if another witness contradicted her. But I hear what you're saying. You're saying that it's not that clear that the water was dripping down to make the puddle. She just commented that water was dripping down, and maybe she didn't mean that was the source of the puddle. Maybe she was just commenting generally.
As I read her testimony and her deposition testimony, she said, I saw water dripping. I don't recall her
You
saying
don't think,
that she
is
saw
there
it
an
dripping
inference
onto
that
the
that
floor.
related to the fall? The fact that she brought it up in the context of her accident?
It could have. Here's the problem.
Because remember, she gets all reasonable inferences.
I agree. I absolutely agree with you on that, Your Honor. She said, I saw water dripping. We don't have any evidence.
It's
other
13
than-
of her deposition, line 12. What did you see when you got to the accident scene? I saw a puddle of water on the floor. Question, your sister described it as clear water. Is that your understanding as well? I believe so. Question, do you know where the water was coming from? No. I just noticed the water on the floor.
This is, that is Miss Robinson's deposition.
That's
Deposition,
May,
yes.
right?
May's deposition. yes.
Correct.
But
Correct.
did Miss
You're
Robinson,
believing Miss Williams, are you talking about?
did Miss Robinson testify that she saw dripping?
No. No, she did not. It was Ms. Williams, was the individual who talked about, and I'll tell you, it's on page 47 of her deposition, it's the record, page 96. I saw water on the floor. I saw water coming down from up top.
Now, is that the plaintiff testifying?
That's the plaintiff, correct, Ms. Williams. Their names are not the same, but
It's May and Rose.
I don't want to mix them up myself.
So was that was Rose testifying?
This was Rose Williams testifying. So
Judge Fernandez quoted from the deposition of May.
May, right.
Correct. So the only person who said anything was Ms. Williams, who said, I saw water coming down from up top. And then she was asked further about that. Do you know where it was coming from? Can you tell me if that was coming from the ceiling or the cooler? Because remember, what they're trying to do, and she wasn't sure, and what they're trying to do is say, you didn't maintain this cooler, therefore it had to be leaking, and it had to be a slow leak, and therefore there's a big puddle. That means it had to be leaking for a long time. And that's where we get into the whole problem of stacking inferences. So if I see
But it's not a stacking of inferences, it's a single inference, correct? You have a puddle of water underneath a cooler, and you have somebody who indicated that they saw dripping coming from above. That's not a stacking of inferences, that's a single inference. It's sort of like my kid standing by a cookie jar. The cookie was present 5 minutes before. He's got crumbs on his mouth. We know where the cookie went, right? So, I mean, I don't mean to be simplistic about it, but it's a single inference as opposed to a stacking of inferences.
Well, I think in this case, we do have to stack because just because there's water or a drop of water at a cooler, that doesn't mean it created that puddle in the aisle.
Right.
But it's dripping from above. So it's coming from a source, and the cooler is located above. So I think it seems to me that it sort of defies logic to say that that's stacking of inferences. That seems to be a single inference. The source was the water above. But maybe you can walk me through how it would be stacking multiple inferences.
So the first inference is you see a drop of water. The inference from that is that there's been a slow leak for a period of time that's going on the floor.
The inference from that is that there's been a leak for some unknown period of time, right?
Correct, but there are...
So the stacking comes in when you have to determine the rate of the leak. So you have to determine that the rate of the leak is sufficient to have the water accumulate over a longer period of time.
Correct.
So a faster leak could mean that same puddle of water could have accumulated in 5 minutes, whereas a slower leak means that it could have accumulated in 30 minutes or 40 minutes. So that's where the stacking, in my view,
Correct.
comes in. Stacking the inference that the leak is causing the puddle, and then determining the rate of the leak to determine the amount of time the puddle is on the water, right?
Correct.
Is that what you mean?
That's exactly it.
That's exactly the answer I expected. Go ahead.
And if you look at the affidavit that they offered on rehearing, it takes all of that and then the fact of maintenance records and all these other things, and they want to put all of that together and infer one thing on top of another to come to this conclusion. But we also don't know if somebody walked down that aisle, spilled something, left it there, because people do things like that, and it
Here's
happened
the
to be
evidence,
in
and
that
I
area.
don't think you have to stack the inferences to come up with the evidence that suggests that there's a genuine issue of material fact. 1, there's a leak. 2, there's a puddle of water. 3, there are track marks, according to May's deposition or affidavit, in the puddle. And if we conclude that those track marks, that the affidavit does not contradict her deposition because the deposition testimony wasn't thoroughly explored, then we can conclude that that's a genuine issue of material fact. Isn't that correct?
I don't think so, because the statement regarding the track marks and the condition of the puddle, when she observed it, when May Robinson observed it, I don't want to mix them up myself, when she came back, we don't know what period of time occurred from the fall to that. So there could have been a couple customers that walked through there. Think about it. Somebody falls, there's not an employee around, they don't know you've fallen.
Well, isn't that exactly the point? Isn't that exactly what creates a genuine issue of material fact?
I don't think so, because we don't know the length of time from when she fell to
It could have
when it
been.
was
It could have
observed.
been. In this record, it could have been a minute and a half.
It could have been a minute and a half, it could have been 10 minutes, it could have
Yeah,
been
but in this
15
record,
minutes.
she gets all beneficial inferences. I mean, does the summary judgment record preclude that inference?
I think the testimony we have here,
I mean, a trial, that can be figured out. I mean, that's what trials are about. But I don't see the deposition involving any discussion of that.
okay, so if we go back to the deposition, she was asked about, she had advised that she took notes. She was talking specifically about witnesses at the time, but she was asked, what did you take notes on? She mentioned that she saw a puddle, and she's asked on page 18, which is 171 of the record, was there any other information contained in your notes? And she just said the name of the insurance company. So it's
What
a
does
little-
that establish?
that she has notes, and there's no information about this, these track marks or the dirt or anything else in this puddle. It sort of
Sure, but
just
wasn't that
appears
for the
after
person
fact.
asking the questions in the deposition? Shouldn't they have explored a little more?
I think, Your Honor, when somebody tells you it's clear water, you take them on their.
I don't take
face
anybody
that
for
it's-
their word. I want to know, and especially in a slip and fall incident, right? You want to know everything about the characteristic of the floor and everything around it, don't you?
I guess.
Well, you
we-
don't
we
need to
could-
answer that question, but
okay.
your time is up. All right, so I assume that you want us to affirm.
Absolutely would love it if you affirmed.
Thank you.
Thank you.
Oh, wait a minute, before you said, anything else, Judge Lodewood, Judge Miller?
No, thank you.
No, thank you, Your
All
Honor.
right, thank you. I'm going to give you 3 minutes for rebuttal, Mr. Stein.
Thank you, Your Honor. Your Honor, we have to emphasize the point that we're on summary judgment here. We don't have to prove our case, okay? We have to show that there's a genuine issue of material fact. What opposing counsel has pointed out is the absence of things. So she didn't put things in her notes. They don't have, she said there were photos. There's no photos in the evidence. Well, they could have subpoenaed any of those items. They could have put those things into the record if they had wanted. And all of these absences, this lack of information, they could have gotten it through discovery, and the absence of it just gives rise to more issues of fact or inferences. As Your Honor pointed out, all inferences are to be construed in favor of the non-movement for summary judgment. Let me read I think it's important, the deposition testimony of the plaintiff in regard to where the water was coming from. So she was asked, when you first saw the water, where was it located?
Where are you reading from?
I'm reading from, it's page 47 of the plaintiff's deposition, which is around page 810 of the record. I have it, it's attached to the motion to strike the defendant's motion for summary judgment. I could count the pages and give
I have
you
it.
the reference.
Page 47 is
You have
actually
it,
page...
okay, great.
It's actually page 96 of the record. Go ahead.
Okay, so she's asked, when you first saw the water, where was it located? And she answers, when I first saw it being the water, I'm walking down there. When I first saw it was on the floor, and that's when I fell, was on the floor. And then when I looked up, it was like dripping down from the top of where the beer was, and all this stuff was where I hit. So the water is dripping from where the beer was, from the beer cooler. Then later, on page 59 of her deposition, which I guess is 12 pages later in the record, she's asked, the liquid that you observed after the incident occurred and the liquid that was on the ground, was it a puddle or was it spots? And she answers, it was like a puddle, right in front of the thing, like a puddle. So it's clear in the record, at least an issue of fact in regard to her testimony, that the water was dripping from the cooler and had accumulated into a puddle. There's no question about that. And we're focused here on Rose's affidavit, deposition testimony, and we have to consider this other thing that was referred to as the plus factor that the appellees referred to in their brief. And as Your Honor pointed out, it's not just the bare fact of her testimony that that this water had dripped, and we just have to guess as to whether it accumulated. We do have the evidence, and it's undisputed in this record, the evidence of the tracks and the footprints going both directions, which means some time had to have been spent, people walking through this puddle, which is evidence that the puddle was there for at least a sufficient amount of time in which the store should have had constructive notice, not to mention the fact that...
It's amazing how quickly 3 minutes go.
Got 15. Oh, it's going the opposite direction. I would ask that the summary judgment be reversed.
All right, thank you very much. We'll be in recess for a panel change.
All right.
I remembered that time.